Good morning, ladies and gentlemen. It's an honor to be here in front of this August gathering. I have a very controversial topic to talk about. Controversial for the reason that pharmaceutical industry, like globally, is divided into innovators and generics, and there's always a battle between what is fair and what is unfair, what is right, what is wrong. But without getting into all that, I'm going to just raise issues which will surely require debate. It will require deliberations, and what will be and should be the law as it will evolve is something which future knows. But I'm here to raise them for you to think and ponder over them and take them home to continue your thought process. Well, before I get into my presentation, I believe that we as a nation need to first understand what is our goal. IP is linked with economic growth, everybody knows. It's linked with the trade, it's linked with development. You cannot say, I want to develop as a nation, but I'm going to treat IP as something different, because the growth today globally is IP driven. It is the know-how which is driving the economy and the trade globally, wherever you can have a look at it. So what do we look at India, say 10 years down the line? And I suppose it requires no guess that our Prime Minister has made it very clear that we want to be a third largest economy globally by 2025. Now that gives us 10 years. Can we reach there unless we review that? Do we have an IP regime which is attractive to the investors, or do we have an IP regime which is a deterrence to the investors? Can we have an IP which is not compatible with the expectations of the investors, and yet expect the investors to come into our country and invest? I think these are the questions which are not easy answers, but they need to be raised and addressed. If we talk about bringing investment and we talk about bringing technology, then we need to understand one thing, that we have to respect IP. We need to then make changes in our laws where we are consistent with what the international IP legislations are, and not become an exception that we have become in respect of some of the provisions which are being criticized quite seriously and for a long time, and they need to be addressed. Now, therefore, if I look at it, I believe that we want to become an R&D center for the innovators and the global industries, and we want investment and transfer of technology, in which case we need to strengthen our patent regime. Now, the challenges which I believe any industry, and in particular pharmaceutical, which has been on a receiving end for a long time, are, we all know, our Section 3D, compulsory license, working of the patent, Section 8 requirement, etc., which I will very briefly dwell upon to raise as to how the courts have interpreted them, and are they sufficient? Or do we require to review them legislative way? Do we require a legal reform? Because the courts cannot come out with policy. They can only interpret whatever they are given to interpret. So if we need to go for legislative reforms and the policy matters, then how do we go about it? These are, again, as I said, not easy questions. And I'm not saying that I have answers, but They need to be addressed, and they need to be addressed now. Now, if you look at some of the statistics, India is an important market as far as pharmaceuticals are concerned. You can see that India in 2005 was at 14th position with $6 billion pharmaceutical business. In 2014, it has gone up to 10th position with $20 billion business. So there is a huge growth in terms of the pharmaceutical industry as far as India is concerned from 2005 to 2015. Now, 2005 is an important figure because that's when the Patent Act opened up the product patent in the field of pharmaceuticals. As far as the current trend of patent filing, PCT filing is concerned, as you can see, it has gone up from 1 million to 2.5 million in 2013. So there are a lot of patent applications which are being filed. There are a lot of innovations which are taking place. Now when we look at how much of it is homegrown in India, just 22% of the PCT filing in India is by the Indians. 78% patent applications in India are being filed by overseas innovators. So today, if we talk about innovative India, then we need to encourage innovation indigenously. And if we need to encourage innovation indigenously, then we need to respect innovation, and we need to protect innovations, and we need to make it very, very simple to the Indian industry that if you want to grow, learn to innovate. We have had a very secured period where the generics have been given almost 25 or 35 years, 1970 to 2005. That's when there was no product patent. So we are talking about almost 35 years, which is half the period of independence that India had since, where we have had a secured market. But the generics need to now understand that they need to start competing with the innovators. For that, they have to start innovating. Now, if you look at how our IP office is placed, if you will find in India, the status of applications with a before examination status is very, very high, as compared to if you look at US, or even if you look at EPO or Korea or Germany. So you cannot have an IP-friendly regime or a patent-friendly regime if you are going to take 6 years or 7 years to grant a patent, when you have a limited period of 20 years for which the patent is to be enjoyed, and out of which you take away 8 years to grant the patent. And once the patent is granted, and if there is an infringement issue, there is a credible challenge to the validity of the patent which is raised, because it's a recently granted patent. Now, what do you say recently granted? You forget about it, that it has been pending there for 8 years or 10 years. So we need to review as to, is it fair to an innovator that he has to wait for such a long period? Now, we don't blame the IP office. Perhaps they don't have the human resource. Perhaps they don't have the technology. Then we need to address that and provide it to them. And one of the suggestions could be, today you have most of the resources that most of the official fee which goes to the patent office, they are not given to them. It all goes to the Ministry of Commerce. Why it is not given to them? Indonesia had a very good example where they left all the fees, official fee, with the local IP office, and the local IP office used all that to augment their human resource and to get technical assistance, computerizations, modernizations, and as a result, their backlog is almost nil today. We can do the same thing. It's just a matter of somebody putting that thought process over there and thinking about it as a top priority. So what are the current challenges, I would say, as far as India is concerned? how to strengthen our efficiency of the IPO Indian Patent Office so that we quickly get our patents. How do we address the concerns of the investors and the innovators? How do we strengthen the enforcement, because we have an enforcement problem? And lastly, how do we create deterrence against piracy? The piracy has been going up the graph despite our law enforcement mechanism being in place, the laws being in place, the enforcement agency is in place, so there is something wrong. There is something which is not working, something which is lacking. And what I can think of is, today there is no deterrence. You can infringe a patent, you can infringe a trademark, and most probably what will happen is, first of all, the litigation will go on for a long time, and ultimately if you lose, you may not really be able to pay much, you may not be liable to pay much damage, because it is very difficult for a right holder to really prove damage what they have suffered, and certainly not, it can't be a quantifiable damage. So therefore, that is one challenge also which needs to be addressed. Now, in terms of concerns, well, as I said, Section 3D, Section 8, working of the patent, compulsory license, and the lengthy court procedures. These are the immediate challenges that need to be addressed. Now, my concern here going to be is not to tell you what should be done, because they are not easy answers, but they need to be addressed, they need to be reviewed, and I'm here to raise them before you. Now, some of the provisions I will quickly touch upon. I'll quickly tell you how the courts have interpreted it, and I will leave you to think how we need to address it in future. So Section 3D, as you have said, new form of a known substance not patentable, unless you can show enhancement of efficacy. Now, there is a huge question mark as to why do we need Section 3D. It's something unique to India. I have till date not been able to get an answer as to why we require 3D. Now, only answer that I have been given is to prevent evergreening. Now, I ask myself this question, that if there is an improvement or incremental improvement in a compound, in a substance, which fulfills the requirement of the inventive step, like any other product, why should you not treat it as an invention and grant a patent? And where there is an evergreening, because whatever has gone into public domain is available, and whatever is now being sought to be protected by way of an invention is an invention. And if it is not an invention, you need to reject it. Where is a need for you to say that, look, there is an invention, there is an inventive step, there is a novel compound, but I'm not granting you patent because you must first show me that there is an enhanced therapeutic efficacy. Why is this? I don't understand. When the matter went to Supreme Court, the Supreme Court said, well, 3D has been actually brought in to take care of pharmaceutical industry. It said so in so many words. Why? So are we protecting the generic industry? So if you continue to protect the generic industry, would they ever turn innovators? That's what exactly happened when before the Indian economy opened in 1991. We protected, we sheltered our local industry. And they never grew. And once we opened up, you have people who competed, and now they are competing, and some of them are competing with the global players. So and ultimately, who benefits? The public at large. So what is the public interest? Where is the public interest? Do we want our own industry, pharmaceutical industry, to grow? If you want them to grow, then you need to take them out of the shelter of 35 years which they have enjoyed. As far as the Supreme Court is concerned, it said therapeutic efficacy. Physiochemical properties are not therapeutic efficacy. But then what is therapeutic efficacy? I can understand the Supreme Court saying what is not therapeutic efficacy, but wasn't it really required then for the court also to say what is therapeutic efficacy? Unfortunately, you find no discussion. In fact, there is a discussion. The Supreme Court says we are leaving this question open. Why should you leave it open? I don't know. I have no answer for that. I will not take too much of time on each case because I think I'm running short of time. So I'll quickly tell you what issues I believe have been raised. Now come to Section 8. Again, we have a unique provision. There must be, now when the Section 8 was incorporated, there was an Iyengar report 1959. Iyengar report said we need Section 8 because you have overseas patentees, applicants who are applying in India. The Indian Patent Office has no way to figure out as to what is happening in the corresponding applications, which are convention applications internationally. And therefore, they may be ignorant of that and granting patent here. Therefore, there must be an obligation for an applicant to disclose